My name is Jacqueline Kagume, and on behalf of the Institute of Economic Affairs, I'd like to welcome you all, and thanks a lot for joining our discussion this morning. This is IEA's, I believe, 16th webinar of 2024. We'll be discussing the law and economics of privatization in Kenya, and on behalf of my colleague and I, who work in the Constitution Law and Economy Program, LEO, we welcome you, and we are grateful that you've made time to join this discussion. So before we get into the discussion, the IEA is a public policy think tank, and our work is basically to inform decision-making in Kenya through policy innovation, research, policy analysis, and convening dialogues to inform public policy. Key of our objectives is raising public literacy on important economic policy issues. And for that, we provide platforms for discussion to basically share some of our analysis and some of our knowledge on different economic policy issues. So that's why we've convened our discussion here today as part of a literacy process to share our insights on the law and economics of privatization in Kenya. But the IEA does have 5 other programs. So working around budgets, we have a public finance management program. We have a program on economic policy, economic regulation and competition policy, trade and development, futures and foresight, popular economics, and then this program that has convened this discussion today. So that's our work, and as we get into the presentation, it's a 2-part presentation that my colleague Leo and I will be making. So as we get into it, I encourage anyone who has questions to please note them down. We have a chat box here. So if you have anything that you'd like to note down as we do the presentation, please note it down, and then we'll try and respond either as we go or during plenary. So that said, we'll also allow you to ask questions during the plenary session. That said, we go to our outline. So that's the outline of our discussion today. So first of all, we'll be, sorry, just give me a minute. Yes, so in discussing this topic, I'll provide a brief background. There are some context issues, basically looking at the state of fiscal finances growth. We'll talk about state corporations generally, and then my colleague Leo will come in and discuss the privatization process under the Privatization Act of 2023. I apologize if you hear any background noise. And then he'll also discuss the current state of play, including various fiscal risks, and then we'll make our conclusions. So that's the outline. If we go to the next slide. So to get started off, so this is part of our discussion today is part of a series. CLA program has undertaken a series of discussions on the issue of privatization. We convened a similar discussion in 2021, which is what is on your screens, and it was basically laying a foundation. So here we were looking at the history, objectives, and the lessons on privatization at the time, and that recording is available on IEA's YouTube page for anyone who's interested. So we began this discussion, and we've conducted a bit of analysis since then. So to advance the discussion a little further. So that's basically this slide was to show you where we've come from, and it's available if you'd like to refer to it. Next, so now going into having discussed or set the stage in the past for those of you who are able to attend the previous meeting, going into what we'll be discussing today, some of the background, just to touch a little bit on this, on CLE's focus on privatization, or what we've been focusing on when looking at privatization. So in understanding the law and economics of privatization in Kenya, we began from the premise that the Constitution of Kenya provides the foundational basis for all economic policy. And this, of course, would inform all aspects of privatization because it's an economic policy issue. And so our focus has been on on the 5 key issues listed here. First, analyzing the constitutional framework for privatization in Kenya, including adherence to constitutional thresholds. And basically, the rationale here was, as this supreme law of the country, we know that Kenya's constitution provides the foundational principles and the minimum requirements that must be adhered to for various public finance management processes, this which of course includes privatization. We know that we have Article 201 of the Constitution, which requires that public finances be managed in a transparent and accountable manner, ensuring the efficient and prudent use of resources. So the process of privatization by itself can be interpreted as one of the mechanisms by which the state can use to advance the principles of efficiency in management of public resources to reduce the fiscal burden of the state. We also have Article 10 that talks about the national values and principles of governance, emphasizing the need for transparency, accountability in management of public resources and public finances, integrity, and so on. And all these lay the basic foundation for implementation of privatization. So adherence to these constitutional thresholds obviously means that the privatization process is conducted in line with it should be conducted in line with the basic constitutional thresholds. So then the second thing that in terms of our focus has been to evaluate the legal aspects of privatization. So this has been the second focus. And here it's basically trying to understand the laws and regulations that are designed to manage that transition of state-owned enterprises to private entities. So having the Constitution at the top. So what are the other laws and attendant regulations? And here we've reviewed the relevant regulatory frameworks, including the Privatization Act, the State Corporations Act, the Companies Act, and the various regulations thereunder. Then the third issue is we have assessed the economic impact of privatization on various sectors. And basically on the overall economy, this was a big chunk of our previous discussion. So basically undertaking comprehensive analysis of how privatization influences economic factors and its overall implications on the economic landscape. Then fourth, the fourth focus here has involved monitoring the performance of those institutions that are tasked with undertaking or managing the privatization process. And here we were basically monitoring the performance of key institutions that are tasked with these functions. This function, we have the Privatization Commission, we have the State Corporations Advisory Committee, and the relevant ministries led by the National Treasury. So basically monitoring to see how efficiently they undertake the process and if the process is in line with the constitutional requirements. So that's the fourth. And then lastly, our last focus has been on then studying the different policy choices related to privatization. So in our previous analysis, we found that that process requires a balance, a strict balance, careful balance between understanding the legal, economic, and constitutional considerations. So to be able to arrive at a most efficient process. So we've attempted to study the various policy choices in addition to international best practice and lessons from other countries to understand what would work best for the Kenyan context. So that's the background in terms of what our focus on privatization has been so far. We go next to, having said that, then what is the basis for privatization reforms? we summarized, excuse me, we summarized the basis for privatization reforms into these five reasons, or the rationale. We classified the rationale into those 5 issues. So the reforms are, first of all, informed by the concept of limited government. And here, it's basically, we all know from our philosophy foundational classes, that the concept of limited government is basically a principle of governance, or a fundamental principle of governance that requires or advocates for government structure to be, government functions and powers to be restricted to only those that are very necessary to maintain or to undertake the core functions of government. So it's basically ensuring that government functions are restricted to, for instance, the functions of enforcement of laws, protection of citizens' rights, and so on. And so this idea is rooted in the belief that the idea of limited government is rooted in the belief that a smaller, more focused government is more effective and more efficient. And so by limiting the government's role, or limiting it from undertaking commercial activities and other non-essential services, then we know that resources or government attention is redirected towards performance of core functions such as governance. So we've listed there some authorities to support this, some of your favorite past philosophers. You can see the list there. So you can we'll make this presentation available, but for any additional reading on that concept, you can make reference to that. So that's the first. We are saying that privatization reforms are necessary to be able to allow the government to redirect its efforts to what its core functions should be. And that first rationale is very similar to what I'll talk about last. But then the second basis for privatization is, in our view, is actually, they're all very connected, is to allow for efficiency in resource allocation. And for economists, I think they would refer to this as the focus on market function. So, and here what we are saying is that privatization reforms they help, or they are driven by the need to improve efficiency in resource allocation. So by transferring the ownership and management of government, certain public state-owned enterprises from the public sector to the private sector, we know that the private sector is more better suited to perform the functions more efficiently. So by doing this transfer of functions, then the market mechanisms are able to work more effectively. So that's the second issue. Then the third basis is on creation of fiscal space. And what we mean by this is that why privatization is necessary, particularly in our context here. We are all aware that Kenya has been facing significant fiscal challenges in terms of our public debt burden. And so one of the ways to prevent or to minimize this problem, or to prevent to address this high debt burden, privatization is one of the avenues in which governments can create fiscal space by generating revenue. First, primarily by generating revenue from the sale of some of the state-owned enterprises that actually add to our financial obligations, that actually lead to blowing up of, or rather increasing our debt challenge. We know some of those enterprises that in the past were constantly on the bailing list of government. So to free up some of the fiscal space, privatization is one of these avenues that can be used by government. So then the revenue that is obtained from the sale of these enterprises can be used to offset some of the public debt, but also to reduce that financial burden on government by transferring the costs to the private sector, the cost of maintaining and investing these enterprises to the private sector. So it frees up those revenues that are very essential for the provision of other services, provision of public goods, but also provision of the very, very essential public services. That's the third. Then the fourth basis is for privatization is to the need for predictability of economic policy. And here, basically, what we're saying is that to ensure a stable and predictable economic policy environment, privatization, if conducted like within a clear, consistent regulatory environment, helps to enhance that predictability of economic policy, both for investors and also even for other business people. So Kenya's constitutional guarantees, including those related to property rights, the rule of law, we know we've seen the link to privatization. And so this process would basically assure investors of the stability and continuity of stability of the overall economic environment and the economic policies. So that's the fourth. And then lastly, which I said earlier would be connected to the first, is that privatization allows government to focus on its core functions. So, I mean, I think from what I've said, this would be self-explanatory, but just to emphasize that it enables the government to concentrate on its core functions rather than undertaking other functions related to management of commercial enterprises. So the shift allows government to focus on its essential roles, which I've already talked about in terms of provision of public goods, and frees up the resources to ensure that they are provided adequately. And then secondly, in addition to core public goods or pure provision of pure public goods, this also allows government to fulfill its constitutional obligations, because in addition to provision of pure public goods, we do know that the government has other obligations like provision of socioeconomic rights as listed under Article 43 of the Constitution. So basically provision of those essential services that have positive externalities, such as the right to education and healthcare, or provision of the services of education and healthcare. So in summary, that's the basis for how we've summarized the basis for privatization reforms. Then going into some of the legal issues, these are just basically like some definitions. Then Leo will come, I'll provide an overview, and then Leo will come in and look at and take you through the process of privatization. So in terms of definitions of state corporations, a state corporation in Kenya is established by order under the State Corporations Act, which is an act of parliament, licensed bank of a national institution or a company where the government holds all or a controlling share. Then we have certain exclusions. So state corporations do not include local authorities, cooperative societies, building societies, or companies where the government does not wholly own or control. Then in terms of the scope, the Kenyan definition includes both commercial and non-commercial entities, regulatory bodies, services, universities, training institutions, and research institutions. Then we have semi-autonomous government agencies, or I don't know whether to call that SAGAs or SAGs. I think these are largely state corporations established under the State Corporations Act and not treated separately under any other law unless exempt, for instance, the CBK and the Capital Markets Authority. Then in terms of public funds, so national public funds are established as state corporations under the separate statutes or some are established by the State Corporations Act. Other public funds established are established predominantly under the PFM Act are not considered state corporations and are controlled by the ministry. So in terms of the overall, those overall definitions, they are provided or available in the State Corporations Act. There are some overlaps. Sometimes there can be some gray areas, but generally that's the classification. Because if you look at the overall definition and the exclusions, but that's a separate discussion. So then in terms of the types of state corporations, we have both commercial and stemming from the definitions that we've provided in the previous slide, we have both commercial and non-commercial state corporations. So for commercial state corporations, these ones operate on commercial principles and aim to be profitable, self-financing and accountable to the stakeholders and the public. And then we have the non-commercial state corporations, which are operationally autonomous from government and are expected to operate on a cost recovery basis. So for the non-commercial ones, they are mostly funded through appropriations from parliament, which of course includes levies and fees. So funded from public sources, and their function is to deliver core services on behalf of ministries. So in summary, that's some of the legal issues, the legal definitions, and then the types. And then now going into the privatization process. So these are defined under the State Corporations Act. Going into the legal process, I think my colleague Leo will now take over from here and discuss the privatization process as listed in the Privatization Act of 2023. Welcome, Leo.
Jackie has provided us with now why as a program, as the CLE Constitution Law and Economy Program, we are focused on privatization. Again, the basis for privatization reforms, and then now providing key legal issues around the designation and also the types. That is very important because by that classification, each both commercial and non-commercial state corporations carry different risks. But again, first we needed to lay the ground because the privatization law was repealed in 2023, and then there's a new privatization law in place. So first, the key things that we wanted to highlight, we will just provide key highlights from the law. So the first, one of the things that changed in the privatization law is the functions of privatization, functions of the privatization authority. First, they changed from a privatization commission to a privatization authority. In terms of legal space, I don't think that there is any significant change with the designation of either, whether it's a commission or an authority, because only commissions that stand out are those commissions that are in the Constitution. The others that are created by legislation can still be repealed from time to time. So, but the change to privatization authority is something that changed. So there are two key things. There are specific. One of the key things that changed in the privatization law, in the functions of the authority, is now the preparation of a long-term divestiture sequence plan. So now the privatization authority is now required to prepare what they call a divestiture sequence plan. And another thing that also changed, but I don't know whether that should have been the function of privatization authorities, them to monitor and evaluate the implementation of privatization programs in Kenya. Largely, because the privatization commission in the past has always, even whether, for example, whether it's the annual reports, whether issuing reports that of consequence that show where the pace of privatization program is something that has not that has not taken place. And then, so primarily now the authority would be now the main focal point in implementation of privatization program. So because they are required to facilitate implementation of government policies on privatization, implement the privatization program, and also take any other measures as required in the act. Secondly, so in the process, there were changes in the process of how the privatization program would be done. So in the past, in the past, the commission would do the privatization commission would develop a privatization plan, and then that privatization plan goes to the cabinet secretary in charge of national treasury, who takes it again, who prepares a report and takes it to the cabinet. And then when it goes to the cabinet, it now comes back to parliament. And then again, once the parliament has given a go ahead, it then goes now to the privatization commission uh, for for implementation. But now the process in the 2023 law is one, the initiation part. It's the initiation part is what the cabinet secretary for national treasury does. So they identify entities for privatization, and we'll give an example of what part of privatization process is ongoing now. Then there is formulation of the privatization program by the cabinet secretary, and that would include issuing uh, uh, now publicly a document that outlines that privatization program. Then the consultation part. And if you all remember, part in this year, there was a notice detailing or what would be what has been considered for privatization and people to present views. And then once that consultation is over, it's approved by cabinet, then that program is submitted now to the National Assembly for ratification. The National Assembly ratifies the program within 60 days. And this is now an important detail. A timeline for ratification of that program has been introduced, 60 days. Again, if you look at the law, there is no recourse. What happens if National Assembly fails to ratify it within 60 days? So once the ratification has happened, then it's published in the Gazette, and then the implementation now starts. So I think this process was changed to ensure that the political economy constraints are out of are things that would be easily dealt with. But again, at the consultation stage, because privatization, largely in the African context, most people consider it as a form of farms. State farms are considered as like nationalistic monuments, to say, if you're to use that word advisedly. And those ones being nationalistic, people take the difference to now whether the people think that they should not be privatized, or whether some of them think that it should be privatized, are things that come out strongly, and you see it in the way court petitions were being filed and the others. But now this is a summary of the privatization process, reading part 3 and 4 of the Privatization Act. Then, so something again that has been introduced is something called the privatization agreement. Uh, so it requires that once in the process, when the privatization authority is executing the privatization program, they develop a privatization agreement, and the privatization agreement will deal with all issues, including the ownership, uh, liabilities, all these other things that the state that are within the operational realm of the of that state corporation. and the party that has now gone through the process and won and won. So again, the then that agreement, once somebody has come out of a competitive process, and I will show how that process is being defined in the law. That agreement will be will be developed, and the execution is not binding unless it's executed by the registered owner of the shares and countersigned by cabinet secretary. Cabinet secretary in this is the cabinet secretary for national treasury. Then the agreement to give privatization cannot be signed until a period for filing an objection has elapsed. There is a process of filing an objection to the privatization, to that privatization program. Then if an objection has been lodged, the agreement cannot be executed until a determination has been made by the tribunal. And then again until the time for filing the notice has expired. Even if no objection has not been filed, people must first file. If that objection has not been filed, the filing period for the notice has expired. Again, if a proposed privatization may result in a regulated monopoly, the authority must ensure agreement provides for regulation of monopoly, and then seek approval for cabinet secretary. Again, this provision is more so untidy because we already there is already a body provided for in the law to make the competition authority to provide guidance, whether technical, and also for them they have the legal authority to regulate market power, and so and that's another thing. So and once after the agreement has become binding, the authority must publish a notice of privatization, being privatized, summary of transaction, the name and addresses of persons to whom shareholding is being transferred to, except for the IPO, for the privatization done through the IPO, among other relevant information. So this is now a requirement that this is a transparency, an accountability requirement, so that everybody knows which firm uh, uh, receives shares of that corporation, and what the summary of that transaction, what it look like. You all remember how Kenya's leading firm, the controversies and claims around the previous privatizations in the early 2000s. And then again, what has been covered in the Privatization Act is the process of privatization. All of them shall be paid into consolidated fund. Again, proceeds from the sale of of the public entity's shareholding must be deposited in an interest-bearing account established by entities for that entity's privatization. So these are public entities where government has shareholding. For a sale of national government shareholding, all of it must be paid to the consolidated fund. Again, the purpose of special account is to protect the erosion of the balance sheet of the public entity. And another thing, uh, the proceeds from the special account must be credited into consolidated fund account within 90 days. That one covers the proceeds of privatization. Then another part is methods of privatization, and this is provided in the second schedule of the Privatization Act. There are three major ways. One is the IPO. I think all of us are familiar with the IPO. This is a capital market. A firm gets into the process of being, goes to the capital markets, obtains authorizations, and all those things. And then again, the shares are sold through a market mechanism. Then the second one is, which is more general and covers a lot of other methods, is what they call the public tendering, which is you invite expression of interest through a notice, specifying entity details, eligibility, submission details, and other relevant guidelines. Advertising will be done in the government tender portal, an authority's website, and at least 2 newspapers of a national-wide circulation. Then another thing is the evaluation of those expression of interest will be done by a committee. That committee, people will be shortlisted, and then the requests for proposals will be provided. Those submission of proposals by shortlisted persons and then they'll within a specified time frame. And then the evaluation of proposals by that technical committee on the set-based procedures and criteria. And again, just to reemphasize what Jackie said, one of the key provisions in the Constitution is the value for money principle. Like it's like whether the state has received the value for money is something that is one of those principles that are already implied in the Constitution. Then there will be selection based on the highest rank bidder subject to reserve price, and also a detailed report to the board of the authority for approval. And then notifications will be done. So the public tendering is now the expression of interest way. And that one you've seen through the Hilton Hotel. One of those that public tendering, the process of public tendering is that one of Hilton Hotel, because they've asked firms interested to provide that interest. And then the third one is sale resulting from exercise of preemptive rights. Then so that one is that one will be done in, according to the company, the entities constituting instruments. And also then there'll be an application of relevant laws if constituting instruments do not provide an exercise of a procedure for the exercising and selling those preemptive rights. So one of the entities that is being considered to be privatized under this is the KWAL, the Kenya Wine and the wine and alcoholic farm manufacturer in industrial area. So that is in essence a summary of the key things in the Privatization Act of 2023. Now, we wanted to provide a smaller context of the state of play. And we are highlighting two issues now from reading through the Treasury's documents, and secondly, looking at the other previous reports, and also what they think the priority for privatization should be. So the 2023 privatization plan, the one that has already been published, but is being litigated in court, has 11 firms, including KLB, including the National Oil, Kenya Seed, KICC, Moya Rice Mills, Western Kenya Rice Mills, Kenya Pipeline Company, the new KCC, Numerical Machining Complex, the Vehicle Manufacturers KVM, and also Rivertex East Africa Limited. So that's the brief description. The process was at the public consultation stage, but the court case has delayed the process. That's why it has stalled at that. And again, we examined the National Treasury's budget policy statement for 2024, and we sampled some of these key things that the Treasury identified that provides the context for why fiscal space will be an important determinant. So one of them is that the National Treasury undertook an analysis of government-owned entities in 2021-22 financial year, 18 of them. And they found that the liquidity challenges, the unfavorable revenue and economic performance. And then 14 of them were found to have accumulated significant arrears, stroke pending bills, now providing that for that implicit risk. And then for 2023-24 financial year, this current financial year, that is almost, the National Treasury is also evaluating 50 government-owned entities using the 2022-2023 audited financial statements. The assessment aims to now provide a report in June, and they're using the IMF health check tool that is called the Government Investments Management Information System. And this report is to give the fiscal risks. What are the fiscal risks from these 50 government-owned entities? And then again, the National Treasury identified. So the National Treasury in the budget policy statement has a chapter on fiscal the risks on the basis of guarantees that it has issued, which are crystallizing. And they showed that some of those they face those they almost they face those fiscal risks, and facing fiscal risks in this means that some of them will be considered technically insolvent for the purpose for that. And then another thing that we also identified is that National Treasury as of June of 2023 had guaranteed loans for three entities, approximately for three entities, and one of them is Kenya Airways of Kenya shillings 170 billion. And most of those includes loans for KQ that that government of Kenya took over those took over them. And again, you'll also need to remember. So for example, like for the case of Kenya West, already government had given up shareholdings to a special purpose vehicle owned by Kenyan banks that had lent money to KQ. And then on the other side, provided direct cash transfers to them. And again, had guaranteed those loans for 170 billion for KQ and two other entities, and are taken over, and they're taken over. And then again, another nuance that we saw: total undischarged GOK loans to government-owned entities was 961 billion by end of 2023, compared to 916 in 2021-22. And then the commercial loans borrowed by government-owned entities is amounted to Kenya shillings 105.52 in 2022-23. So first, those undischarged loans are loans that are provisions that they've already requested National Treasury, and National Treasury has provided to them, but they've never been able to. Those government-owned entities have never been able to pay them back. Again, pending bills among state corporations were high, 443.59 billion as the end of June 2023. Majority of those includes unpaid contractor fees for capital projects, undischarged tax obligations, and also unremitted employer pension contribution. So this is state of play for in terms of fiscal affairs. What is it looking for? What is it looking like for them? And again, for number 6 on the pending bills, one of the things that we also discovered in the IMF publication on economic and the program performance, one of the things that you notice is the rise in non-performing loans actually follows that chart shows that the rise in non-performing loans follows the same trend in pending bills. So when the share of pending bills, as the share of pending bills goes up, the share of NPLs also goes up. But again, that having known all that, that was not even the most interesting thing. And the most fundamental thing that I think we should pick from this webinar, if we've not picked anything else, is this. So, as Jackie has explained, there are two types of uh, state corporations: commercial and non-commercial. For are 46. For non-commercial, there are 201. For commercial enterprises, so the National Treasury undertook a fiscal risk analysis in in 2021, but using the 2019-2020 data. First thing that they found was that commercial enterprises accounted for 85% of all revenues, of all total revenues collected by state corporations. So it's 85%, all these commercial enterprises. Then number two, and which is the most important point, is that the same commercial enterprises accounted for 89% of all total liabilities of state corporations. So, and that's the thing, that the fiscal risk concentration is in these few state corporations, and most of them fall under the category of commercial enterprises. So, and that's a fiscal risk assessment that using the 2019-2020 data, given on the way we understand Kenya's economy at the Institute of Economic Affairs, we think that data is highly unlikely that even other fiscal risk assessment is done, that it will find a different it will find a different view, that all these commercial enterprises are responsible for 85% of total revenues collected by state corporations, but they are also responsible for 89% of all those total liabilities, which shows you something, that first, there is demonstrable value in that, but secondly, in those state corporations, but secondly, that those risks needs to be done by those risks need to be managed by in a way that maximizes shareholder value. Another thing that we also and majority of them are in energy and transport. Majority of those are in energy and transport. Another thing that we wanted to highlight is that on the basis, so one of the things that you notice that we mentioned, that there is a basis for government, for the reason why we have a government. And in Kenya, our basis is distilled into two things, largely two things. One is to provide, and now this is convention, that a government should provide public goods. And secondly, a government should be able to provide, to meet the constitutional obligations. The constitutional obligations. And those constitutional obligations are few, and most of them have positive externalities. But if you look at that, what has been advanced to, so for example, in 2022-23, in 21-22, that an advance of close to 961 billion to all state-owned entities, although that number is cumulative, that shows the significance of how state entities is taking away uh, that the the budget provisions that would have gone to either meeting the constitutional obligations or meeting those public goods. So, like at the moment, something that really it's really troubling is that you all realize that some of the key things like vaccines, uh, key vaccines, like whether for key vaccines, are not available. And it's not just vaccines for children, but also other other vaccines that are required. So like that are required for whether it's whether it's yellow fever and all the other things are not available. And because the focus of the state has gone into something else differently, because we evaluate policy priorities, budget policy priority on the basis of what has been allocated, not on the basis of what the state says. The state can say that we are interested in everybody having vaccines, but at the same time uh, allocate fewer resources or take that there is a 1 year lapse ever since government of Kenya ordered vaccines. And that is something that we want to see those resources in a different direction. So in our conclusion, uh, uh, financial risks due to government-owned entities, especially commercial enterprises, are crystallizing. Sorry. Number two is privatization without more focus on commercial enterprises will not provide any meaningful fiscal relief because majority of those liabilities are in commercial enterprises. And then to provide also context, and that one does not mean that we are saying that that non-commercial enterprises should not be looked at. What we are saying is that based on the current data, that these risks lies in those commercial enterprises. But secondly, there are efficiency gains to be made if those non-commercial enterprises are correctly are categorized in a way that allows first that some of them an evaluation in the Mungano the Abdi Kadir report in 2014 found out that some of those parastatals undertake similar functions. So most of them so they are overlapping. So most of them would mean that some of them would have to be merged. There also another finding in the Mungano report is that designation, there is no need to designate regulatory institutions and also as state corporations. They are regulators. So they have so there's a process on first the legal issues, how the designation is done, but secondly, another thing is on there's a legal issue on how designation is done, but there should be entities that are only uh, uh, that only provide whether that provide a regulatory function on the basis of what government of Kenya society below should not be a state corporation. Also, something else that pending bills out of state corporations are significant and play a bigger role in growth of NPLs. And that is something that's an intervention that government should be able to should be able should that privatization, the members of parliament and the general public and all these other stakeholders should look at the trade-offs. Are we willing to trade off now NPLs to that the volume of debt continues to grow, which has also implications for the business operating environment. And let's not also forget that all these government entities are funded through taxes, and a tax being a distortion should. So the proper question that I should frame to all of us, and as I end as I end this presentation is, are we ready for that trade-off of funding ineffective and inefficient, and also uh, government-owned entities with dual mandates uh, on the basis of that those taxes come from a Kenyan taxpayer, and then also that the same government-owned entities, and especially in Kenya Kwanza's plan, they identified something that was real. We thought that was important. That government uh, government has been a drag, playing a bigger role in affecting market decisions, and they identified two. One of them was in public debt, but secondly, also state corporations. And they would say that the main focus of privatization should be on that basis that state, these state corporations are affecting how private sector players in Kenya allocate capital, because you cannot allocate capital where a state-owned entity is. where stored an entity is, and they are provided with a legal cover. MPs are providing them with money. There is no incentive to perform, or even the incentive to provide better services. So is that trade-off something that Kenyans should really consider? And that's why we're saying there is a real basis for privatization reforms. Back to you, Jack. I end at that.
Thank you. Thanks a lot, Leo. So that concludes our presentation. We've taken you through the basis for the privatization reforms, looked at the newly enacted Privatization Act, the functions of the authority and the process. Leo has explained about the proceeds of privatization, the methods, and then concluded with state of play, the current state of play. So as I mentioned at the beginning, this is basically a literacy forum for us to share some of the insights we've extracted from our analysis of the state of play of privatization currently. So I don't know if anyone has a question, because I don't see any in the chat box, or if the presentations were self-explanatory and we are all happy. Does anyone have a question? So the first question is by Simon. Says, thank you to the two presenters. What are some of the examples of non-commercial state-owned enterprises? Then there's a question. I think, Leo, you can pull back up the presentation, because I think we had that slide. And then Eric Musau asks, will privatization affect pending bills? That is, could there be public entities which owe each other and which owe KRA that could change the overall stock of pending bills? And then, yeah, Emmanuel, they're appreciating the presentation. Thanks. So, Leo, can you put back up the presentation?
Yes.
So does anyone else have a question? If not, I'll ask Leo to try and respond to the questions first, and then I'll see what to add. So go back, next. So just go to, you had provided a list of those.
So,
Yeah.
non-commercial state corporations mostly national hospitals, water bodies, water entities, the development, the regional entities. They also include universities. They also include regulatory entities. They also include so some that provide services at the national level, including Kenyan National Examination Council and the rest. And that's why we've raised the issue of designation, that some of these regulator, for example, regulators should not be in that list, and the like. But those are considered non-commercial state corporations. And then the question by Musao, will privatization affect pending bills? Could there be public entities that owe each other and which owe KRA, and that could change the overall stock of pending bills? So some of that are risks. So let me give an example. One of the cabinet proposed actually a write-off for sugar farms. When we looked at those sugar farms, the three of them, almost 50% of that of the three farms, almost 50% of them were on taxes. So some of it was income tax, some of it was on VAT. Others were on obligations that they already deducted from employees, but did not send to KRA and that. So whether will privatization affect pending bills? So could there be public entities? So Treasury will have now to propose ways in which that whether those public entities that owe each other and owe KRA. So for KRA, it will be now a tax abandonment, and that is a question that would be best answered by members of parliament. And there is a stage where parliament will be approving that privatization program, and they'll consider all these issues. Secondly, uh, uh, the overall stock of pending bills, the pending bills that would be harmful to the economy if not paid for are the pending bills already owed to the contractor. All to the not the contractor, like any service provider that just deals with government. And those are pending bills that whether we are seeing people from reporting in the newspapers, people showing up in offices, people showing up in offices in very distressful times, whether people uh, getting people who are already sick, people who are already uh, so that's a problem, and that's a general problem that government the government of Kenya needs to address. So there is a pending bits verification team that is already going on with uh, verifying all pending bills owned by audited by state corporations and by. So we'll see what they'll do, but that's a very important question. So back to you, Jackie.
Thank you. Thanks, Leo. Um, there's one final question here by Jairus, and he's asking that based on the analysis by the National Treasury to which you referred, where commercial corporations accounted for 89% of state corporations' liabilities, does this mean that these are the ones that should be targeted for privatization? So I think, Leo, you referred to that in your presentation. Do you want to respond to that?
Yes. So Jairus, that's a very good question. So implicitly, I'm just saying mathematically, if mathematically that the risk is in commercial enterprises, and there are few of them. But you see, so there are two objectives. So when you're doing privatization on the basis of having a limited government and also being able, you'll have to look at the entire scope. But if you're doing privatization on to gain that fiscal relief, then you will have to you'll have to think about you'll have to you'll have to think about. So when you're doing it for fiscal relief, you'll have to uh, you'll have to consider now the mathematical issue, which is these are the ones that are contributing largely to the problem of on fiscal risk. So you'll have to deal with them. But I think you'll have to look at the entire all the state corporation landscape and just make a determination that we want to do this and do it right and for one off, not make it a thing that that will go on in perpetuity, because that is what happened in 2003, and that is something that and also happened in 2014 when the Mungano report was done, and now we might also see the window of this privatization reform again disappear if they consider. But mathematically, Jairus, that's what I was applying. Thank you.
I think we can end it at that because I don't see any other questions. So I don't know if, Leo, you have any one last word because we make final remarks. Anything that you'd like to add or before I conclude?
Yeah. So we think largely that there are political economic constraints that faces privatization, and mostly it's due to what politicians are able to uh, the way politicians have convinced, and also those who direct policies in ministries, including the ministers, the principal secretary, because this one creates a there is power differential, and people want to retain control for obviously pecuniary interests, for financial reasons, uh, for power, for cloud, and that kind of a thing. But for us, as taxpayers, and also as Kenyans who want to see effective public services, that is something that we must and we should demand that if a private sector firm is making a return of 13% outside inflation, outside the inflationary cost, a return outside inflation. Why is it that after taking a billion, a trillion, 1 trillion shillings, close to 1 trillion shillings, state corporations are making a return on investment of less than 0.1? Why? And that's the most important point. So if you value capital, if you value resources, and you understand that there are trade-offs, and you understand that there are trade-offs to and you understand that there are trade-offs, then privatization is a good anchor, is a good anchor to approach this issue. So and that's the thing. So we need people to understand that we cannot make an argument, say we should not pay for fiscal risks that are crystallizing at Kenya Power and Lighting Company, we should not pay. But say again that those entities should remain under government control. If government people who've been tasked to run those entities make a mistake, it's us the taxpayers who carry the load, and that's the thing. So I think myself, as somebody who lived in this country and understand this country, that my taxes should go to those entities that would provide those constitutional obligations and also provide public goods, so that we don't get swept away by rain and say we are funding Kenya Power and Lighting close to, or giving Kenya Airways close to 500 billion shillings over the last 10 years. And then we get swept away with rain. So we have to choose one area. What do we want? What do we want? Do we really want those services, or we want to state corporations? Because that the state's corporations is something that was created after we gained independence and when people wanted to make control institutions. But now we have to, it has to go to, the markets have to provide better outcomes. Thank you so much.
Great. Thanks a lot, Ilio. So that concludes our webinar for today. On behalf of the program and on behalf of the IEA, I thank you all for joining this discussion. Thank you for the few questions, and thanks for the interaction. We appreciate your presence, and we look forward to further discussions on this. As I mentioned when we began, this is the second of this series that we've had. The presentation will be uploaded on IA's website. Together with the recording of this will also be on YouTube. So as I mentioned earlier, if you'd like to cross-reference to what we discussed previously, you can access that there. We'll also summarize our findings here into a brief that we will share, a written brief that we will share and will be available as well on IA's website. So again, on behalf of IEA, please, for those of you who are not members, IE is a membership institution. If you're interested, please reach out to our communications team and they'll guide you on how you can be a member and experience